All right, if you're gearing up for the Queensland bar exam, you know expert evidence is a massive deal. It's one of those topics you just can't afford to get wrong. So today, we are going to nail down the absolute essentials. That's rules 424 to 427 of the UCPR. Let's jump right in and get these rules locked down. Here's how we're going to tackle this. First, we'll look at the scope in Rule 424. When do these rules even kick in? Then we'll define our expert with Rule 425. After that, the big one, the overriding duty in Rule 426, and we'll wrap up with the mechanics of it all in Rule 427 and finish with some key takeaways for your exam. Simple as that. Let's go. Okay, let's kick things off with Section 1, Scope. This is all about Rule 424. And look, this is your starting point, always. Before you dive into the deep end of expert evidence, you've got to ask, do these rules even apply here? This is that classic threshold question you're going to see on the exam for sure. So you might be thinking, okay, do these rules just apply to every single expert in a case? Is it a blanket rule? Well, the answer is a big, fat no. And Rule 424 is the reason why. It lays out some really important exceptions that you absolutely have to have in your back pocket. Okay, so here they are, the key exclusions from Rule 424, subsection 1. Some of these are pretty intuitive, right? A party to the proceeding? Of course. Someone whose own conduct is being debated? Makes sense. But the one you've really got to watch out for, the one that loves to pop up in exam questions, is the treating doctor. Now, a treating doctor is not considered an expert for the purposes of these rules. But there's a catch. It's only as long as their evidence sticks to what they actually did. You know, their examination, the treatment they gave, the advice they provided. They're basically a witness of fact in that scenario. The second they start giving a broader medical legal opinion, an opinion for the court case itself, bam, they can get pulled right back under these rules. It's a fine line, but a crucial one. All right, so we figured out when these rules apply. The next logical step, right, is who do they apply to? This brings us to Section 2, defining the expert, all thanks to Rule 425. So Rule 425 gives us the official definition, and you're going to love this. It says an expert is someone who is qualified to give opinion evidence as an expert. Kinda circular, right? An expert is an expert. Thanks, UCPR. It doesn't really give us much to work with on its own. To really get what qualified means, we have to go to the case law. That's where the real meat is. And the case you absolutely 100% need to burn into your brain is Makita Australia Pty Limited versus Sprawls. Seriously, if you remember one case name from this whole explainer, make it Makita. This case gives us the definitive checklist, the step-by-step guide that courts use to figure out if an expert's opinion is even allowed in. It's basically your secret weapon for any exam question on this topic. Okay, let's break down this Makita checklist. You've got to hit every single one of these points. 1. Is there even a field of specialized knowledge here? 2. Is this witness actually an expert in that field? 3. Is their opinion really based on that specialized knowledge? 4. And this is where so many reports fall over. Have they spelled out the exact facts their opinion is based on? And can you actually prove those facts? And finally, number 5. Do they connect the dots? They have to explain how they applied their knowledge to those facts to arrive at their opinion. They have to show their work, just like in math class. You miss even one of these steps, and that expert evidence is in serious jeopardy of being thrown out. So we know what an expert is. Now we get to the real heart of the matter. This is Section 3, and it's all about Rule 426. I like to call this the golden rule of expert evidence because, honestly, it underpins everything an expert says and does. Every expert lives with this built-in tension. On one hand, you've got the party who hired them, the one cutting the checks. But on the other hand, you have the court. And Rule 426 could not be clearer about who wins that fight. The expert has an overriding, paramount duty to assist the court. And that duty trumps everything else. It completely overrides any loyalty or obligation they might feel to the person paying their bill. This isn't just a nice idea, it's a hard and fast rule. And this quote from President Safronov just says it all, doesn't it? The duty to the court overrides any obligations owed to the party who pays the expert's fees. Think about what that really means. It means an expert might have to say something that actually hurts the case of the person who hired them. That's how powerful this duty is. Their job isn't to be a hired gun. Their job is to help the court get to the truth. So that's the ideal. But what happens when an expert forgets all that? What happens when they stop being an impartial assistant to the court and become a cheerleader for one side? Well, let's look at a classic cautionary tale that shows you exactly what goes wrong.
The case is Hobbs versus Oil Drive PT Lied Limited, and it's a perfect example of what not to do. Here, an expert's entire report got tossed out. Why? Because the expert totally crossed the line. The judge described the report as argumentative, adversarial. He even called it an inappropriate polemic. Ouch. The expert had become an advocate, a fighter for one team, instead of an assistant to the court. This is your go-to case for an exam answer when you need to show the consequences of breaching that big duty under Rule 426.
Okay, so we've got our expert defined, and we understand their number one duty. That brings us to our final piece of the puzzle, Section 4, which is all about Rule 427. This rule is about the nuts and bolts, the how. How does an expert actually give their evidence? And the general rule in Rule 427, subsection 1 is super straightforward. An expert gives their evidence in chief only by a report. That's it. That's the default. No big, dramatic oral reveals in the witness box. Why? Well, it's all about fairness and preventing trial by ambush. Everyone gets to see the expert's full opinion in writing beforehand, so there are no surprises. But, there are always exceptions, and Rule 427, subsection 4, gives us 3 of them. An expert can give oral evidence in chief in a few situations. 1, to respond to another expert's report. 2, to talk about issues that are popped up for the first time during the trial itself. Or 3, if the court simply gives them commission or leave. These 3 exceptions are absolute gold for exam writers, so please know them inside and out. And this quote from Justice Chesterman really gets to the spirit of Rule 427. He says the point is to prevent surprise at the trial. It's not meant to stop a barrister from walking their expert through their report to help them explain it. The rule isn't there to make things difficult, it's there to make things fair. It just ensures that the game is played with all the cards on the table. Okay, we have flown through a lot. Rules 424, 425, 426, and 427. So let's pull it all together. This next slide is your cheat sheet, your at-a-glance summary, perfect for that last-minute cram session before the exam. Let's nail this down. Rule 424, think application, and know those key exclusions, especially the treating doctor. Rule 425, that's your definition. Your trigger here is the Makita checklist for admissibility. Rule 426, that's the big one, duty. The duty to the court is paramount, period. And finally, Rule 427, that's the method. Evidence is by report, unless, and this is key, one of those 3 exceptions applies. Get those 4 things straight, and you are in a really, really good spot. So I'll leave you with this question to think about, because these rules, they're not just exam fodder, are they? They're the ethical tightrope you're going to walk every single day as a barrister. So ask yourself, how are you going to balance your absolute duty to your client with making sure your expert witness never, ever forgets their overriding duty to the court? That's the real test, and it's one you'll face for your entire career at the bar.